there was nothing to say here that they met the element of proven identification that Mr. Jones performed the shooting. The second part I would like to say, Judge, not only was he I almost want to say you have to show identification. And you have to rely on the evidence of the testimony that came. And if someone would have came and said, that's Mr. Jones in the gray shirt, I would make my argument. But no one said that. If there was some fingerprints, some ballistics or something of that nature saying it was Mr. Jones, then I would have to argue that. Furthermore, Judge, whoever that individual, just for the sake of argument, murder is an intentional crime. And I'm not going to belabor the issue of that. It's undisputed that a vehicle was shot up, whoever that third person was, because as I said, I was always informed there was 3 suspects. Whichever the third individual was, 2 guns was already out there shooting before that third person even got involved. And shots were being fired in that third individual's direction. I let Your Honor make your own analysis on that one. Judge, I understand what you're saying about whoever it was and self-defense and things of that nature. But Judge, we just can't get beyond the point that no one took the stand and said, Mr. Jones was driving a car, fleeing and eluding, and I seen him driving that car. So when it comes to the fleeing and eluding charge, no one said he was driving. Resisting obstruction of an officer, prosecutor did a great job of trying to rehabilitate it, but the officer said, I said to stop, and then I said to stop, and he voluntarily stopped. They didn't, he was hopping fences before the officers even came into the picture. So it wasn't like he was hopping fences disobeying the officer. He was hopping fences before they got there. They yelled at him twice, he voluntarily stopped. So I don't believe there's no resisting, obstructing of justice or assaulting and resisting obstruction. Judge, I appreciate your time as always, and I would like to say it, but Judge, I just don't know how you're going to get past identification. It's not there.
Thank you, Your Honor. With regard to identification, court saw the video. Court views the video, particularly the Vape World video. You have a really good look at the person in the gray sweatshirt, black pants, wearing flip-flops. We have testimony from Officer Gilby saying he observed those 2 people in that video get into the red Malibu. He chases that red Malibu. The red Malibu crashes. There, Officer Gilby arrests Mr. Jones, Mr. Smith. We see on the video, person who's the driver running away. Same person we see in the Vape World video.
Now, this is where the identification argument starts to fall apart. The defense is saying there's no direct witness pointing to Jones, but the judge is looking at the bigger picture. The surveillance footage, the clothing, the flip-flops, the getaway vehicle, and Jones being arrested after the chase. The question is, when all those pieces line up, is that enough to establish probable cause? The judge clearly thinks it is, and that decision is about to change everything.
That is Mr. Jones. Mr. Jones is later taken into custody by Corporal Maxey. He's identified by Corporal Maxey, by Officer Stanky, by Detective McDonough here today as the person that was arrested there. Now, yes, he's no longer wearing the gray sweatshirt. He's wearing a black t-shirt. However, 2 important facts I would point out regarding his apparel. First of all, the flip-flops. He's wearing flip-flops at the time of the shooting, and then he takes off running. Now he's arrested in socks. Interesting coincidence. Additionally, if the court reviews the video, the pants he's wearing are distinctive. They're not just distinct black pants. They're black pants with some sort of material. You can see that very, very clearly in Stanky's body cam video. You can see it clearly in the Vape World video. Additionally, His ID is found in the getaway vehicle, in the Malibu. So all of those things tie him directly to that. So I think that is sufficient, particularly for a probable cause standard, to establish identity, establish that he is the person there in the Bakewell video and the Bombay video, firing shots out into the neighborhood. Both defendants are on video shooting at the victim in the case. The victim is murdered by a gunshot wound. People have met its burden with regard to the murder charge as well as all of the attendant counts that go along with that. We would move the court to find over on all counts.
The court is listening very closely to the testimony in this case, and I share in that view that of sitting here watching, regardless of how this ultimately plays out, of these young lives, it particularly is somewhat distressing if I take a matter of personal privilege, not having anything to do with the court's decision in the case, that I watch these young people that look a lot like me and they end up in this situation. It's horrible. It's also interesting now, as everybody's discussing the neighborhood in this scene, I grew up around there. So I know exactly where everybody is as they're going through the whole thing and what they're doing in terms of where they're going and the like. Just say that as a preface to this, because this whole thing is just, it's sad to watch. It's sad to watch a young man come out of, or walking down the street someplace and then pull out weapons that are modified to go from semi-automatic to automatic weapons, just indiscriminately firing in an area where at any given point in time, that area, there are just a whole lot of folks just going around either trying to get pizza, go to the one of the Asian stores that are down that way, quite frankly, go down to the library, which is a little bit further down, just indiscriminately shooting. It quite frankly, it's tragic enough that one lost their lives. It's, I guess, in some bizarre way, fortunate that there weren't more lives lost. With respect to the proofs in this case, start with the ones that for the court, from the court standpoint in terms of testimony, are as to Mr. Smith on counts 2, 3, 4, 5, and as to Mr. Jones on counts 2, 3, 4, 5, 6, 7. On those, I don't think there's any dispute that the people have shown by a preponderance of the evidence that those offenses have been committed and that this defendant did. The one issue with regard to the homicide that is raised by Mr. Jones' counsel could be significant if one doesn't look closely at the videos. Mr. Overwater, I think, is correct. That is, when you look at the video real close and you see the individual, you see the pants. I didn't need to know the brand of the shoe. I knew that those shoes were not ones that would stay on. And then the individual, Mr. Jones, is found going through a neighborhood over fences, ends up with no shoes, just socks. And at some point, somewhere, I would suspect shed that the white sweat or white hoodie or gray hoodie, so that he's dressed in the fashion that he's dressed in at that time. But those pants were distinctive. It was interesting that I was going to bring it up and go into it in a lot more detail. But I think when you look at those pants, it's real clear that that's him. That's him that's in front. You also look at some of the facial features that you can see, and it was clear to me that it was Mr. Jones. To any extent that one wants to argue it, I would dare say that in essence will maybe raise an issue of material fact that has to be decided by a finder of fact. But this court is convinced that that was Mr. Jones at that scene. That was Mr. Jones firing that weapon. And I don't think it matters for the sake of bind over that I attribute that bullet to particularly bind over an open murder for these individuals, that I attribute these to which gun, which firearm, which defendant it was fired. At some point when they started acting, they were acting in concert with each other because they were both firing, both unloading a large number of bullets into that strip mall, and then jointly both got into that vehicle and drove off. I think the record also shows that one could infer that it was Mr. Jones, is his identification, his items of ownership, as well as a weapon, are all found in that vehicle that crashed on Lorraine Street. So for those reasons, and so that we're clear, as to Mr. Smith, I don't think there's any issue as to identification. I mean, he's clear as a bell the moment he's climbing on the top of that officer's vehicle trying to get away, that's him. So for those reasons, the court would find that the people have indeed sustained their burden of proof in this case. And so that the record is clear as to Mr. Omar Smith, I would bind the defendant over to stand trial on counts 1, 2, 3, 4, and 5, taking into account all of the information and evidence presented during the course of this preliminary examination. And likewise on Mr. Jamal Jones' case, if that goes off one more time, I'm taking it.
And there it is, the ruling that sends this case to the next stage. The judge has found enough evidence to bind both defendants over for trial, meaning this courtroom battle isn't over, it's moving forward. But remember, being bound over is not a conviction. The defendants still plead not guilty, and the ultimate decision will come later. So now the big question is, will the evidence that convinced this judge be enough to convince a jury?
On Mr. Jamal Jones' case, I would bind the defendant over to stand trial on counts 1, 2, 3, 4, 5, 6, 7, based upon what the court has said during the course of its rendering of its decision, and the court also indicating that they've taken into account all of the evidence which has been adduced. Therefore, the defendant are bound over to stand trial. As to the circuit court arraignment, gentlemen, you waive formal reading of the complaint, of the information.
Yes.
And how does your client plead?
Not guilty.
Defendants, having waived formal reading, pleading not guilty to all counts, court will enter that not guilty plea. Pretrial in these matters will be set for
April 6th at 1:30 for Judge Blue.
April 6, 2026, 1:30 before Judge Hamoud. Bond in each case will continue as denied. Thank you.
Thank you. And I've been asked, oh, I'm sorry.
Got it. We'll get that in a moment. Okay. All right. Thank you. Yes, sir.
I was presented with, someone suggested to me that there may be some precedent for a juvenile like Mr. Smith to be able to hug his family. I don't know if that's the case or not, but someone suggested that there was some precedent for that, and I
don't know what kind of precedent you might be speaking of. As
just sounds like that's
something that sometimes happens. That decision, and I do not allow it in my courtroom in that way. I just don't, and never have. And those decisions as to that contact, I leave with the sheriff's department and our detention center. So I'm not going to allow it. I certainly understand it, but I'm not going to do that.
Yes, Your Honor.
With reference to how folks are going to exit the courtroom, how did you wanted this side to go? All right, so what I'm going to ask is that I'm going to allow those to go out with the victim's advocate. Those that are on this side, I'd ask you to please wait. I'm not picking sides and doing that. I'm just trying to get everybody out of here in an orderly fashion. Thank you.
And Your Honor, as
Yes,
to
sir.
exhibits, do they stay with the file or do we take them?
I will, you don't,
I don't believe so.
no, I will return them to the respective parties. Like this.
I approach.
Yes. The people's exhibit is this one, and I think those belong to defense.
Oh, these are mine. Yep, thank you. Thank you.
Everyone have a good day. Good.
Yeah. Did you need it for?
Yeah, I do.
Or can I approach the information?
Yes. And just give this to me.
Give our exhibits.